we've only got time for about one question each. So, David, for you, what are the difficulties in helping clients manage their trade secret assets?
The main difficulty is getting to have someone in the company, one person in one department that's in charge of it. And therefore, it's their responsibility to keep up with them, list them, and handle outside counsel or any other stakeholders, such as HR. And if you can get a company to do that, they can create a trade secret culture.
How difficult is it to get that done?
Well, it might take a budget, and so I think in the future what I'm going to do is I'm going to take Reg's slide of the top 10 verdicts with me, and then when I go and meet with these folks, I'm going to show it to them, and it might be easier. It's easier said than done, especially in middle market companies like I deal with.
For John, you've explained how state trade secret law and the DTSA interact or overlap with respect to the inevitable disclosure doctrine. How do they interact or overlap with respect to interim remedies?
Well, the first one that's most obvious is that in the federal statute, the seizure remedy is an express part of the statute where it's not under the uniform statute. The second one is that the law is much more developed in some states than others, and much more developed in certain kinds of things than others. I often look at cases in North Carolina if I'm dealing with pharma. I practice in New York and New Jersey. New Jersey has a big pharma industry, as does North Carolina. And sometimes I get cases where the facts there are really pretty detailed about things related to that industry. So you may just have a more developed area of law based on industry in one state versus federal. And that can inform the court on what they're going to do with respect to an injunction. The other thing is some states are organized differently, and that has some consequences with respect to applications for injunctions. For example, in New Jersey, but not New York, there is a chancery division. In Delaware, there's a chancery division, and they get most of the applications for where a big part of the case is for equitable relief. They don't get all of them, and you can apply for equitable relief in other cases, but it affects how things proceed. And therefore, you get a body of case law in some states that's a little different than in others. And the other thing is that sometimes a federal court will look to a state court for help. You know, so if there's really good law in state law, you might want to look to it. Not to go too much on about it, but you know, you can select in an agreement, say a joint venture agreement, like Reg mentioned. If you have a joint venture agreement, you can stipulate as to what law applies. So let's say I pick the law of New Jersey. The case might not be litigated in New Jersey, but the judge in another state, when considering an application or an interim remedy, is going to consider New Jersey law if both parties agreed to it. So that can affect what kind of remedies are available because somebody was smart enough to look at the law ahead of time in that state and decided that they wanted it.